Recording in progress. Good morning. I'm Judge Tammy Long Hayward. This is the civil calendar for Courtroom 304, Clayton County State Court. I'm going to call the 10 a.m. civil calendar. First case on the calendar is Verena Green, Kyan Green versus Kylan Johnson and Allstate Insurance.
Good morning, Judge Tony Greer on behalf of the plaintiff. We do no longer need the hearing for this case. We have settled, the portion for that filed the motion. I believe that's correct. Attorney Williams is online for the defense.
Okay.
Good morning, Judge Kyle Williams for the defendant. Ms. Greer is correct in part that we have reached a settlement for the defendant's portion of this case, and we have received the discovery. UM is still involved, and so I'll let Ms. Tucker, who is also on the line representing Allstate, speak on their behalf.
Alexis Tucker on behalf of Allstate. We have withdrawn our rule NICI, so there's no need for the hearing this morning because we did receive discovery.
All right. All right. So for those of you who remain in the case, I look forward to seeing you either at some other conference or at trial. And thank you all. I love the word settlement, consent, agree. Those are beautiful.
Thank you. You have a good one.
Your Honor.
Take care. All right. It is Jessica Wilson versus Jamario Terrell and State Farm Mutual.
Your Honor. Good morning, Your Honor. Abigail Moody for the plaintiff, Jessica Wilson, and we are on schedule for a summary judgment hearing this morning.
Yeah. All right. I see that the defendant is listed as pro se on my calendar, but is there anyone here for the defendant?
Your Honor, Ryan Brightman here for State Farm. The named defendant has not made an appearance as far as I'm aware.
Okay. All right. So this is the motion for summary judgment.
Yes, and so we'll be ready to proceed on that. I would anticipate 5 minutes.
All right, no problem. All right, let me go ahead and run through the rest of the calendar. Lisa Matthews versus Cerberus SFT Holdings, First Key Homes, Georgia, First Key Homes of Georgia, LLC. Then there's a second First Key Homes of Georgia, and then for FHK SFR, Proco. Ooh, that's a lot. All right, anybody here for any of those entities?
Jordan Mahoney here, present on behalf of the defendants.
All right.
We have a motion for summary
You're
judgment.
covering all of those people, all of those corporate people. Okay,
that's right.
That makes it easier. All right. And anyone here on behalf of the plaintiff? Okay. All right. So what I have is that the case was dismissed recently. Did you not get?
Oh, sorry. Go ahead, Judge. I didn't mean
No, I was going to ask you, had you not gotten that information, Mr. Mahoney?
I had not gotten that information. I haven't had a dismissal come through on my end.
Okay, Ms. Powell, I have that it was dismissed with prejudice on May 31st. Have you seen the actual document, the actual dismissal?
Pulling that up now, Judge. I will send it over to you once my CPU8 comes back together.
No problem. All right, yeah. So, Mr. Mahoney, that's what you're looking for if you want to check the, and this is Matthews versus Cerberus et al., right? 2021 CV 00549. So my note says it was dismissed, but I'm not infallible. So we'll look it up and make sure and determine whether that's actually, because I can't imagine that they wouldn't have sent you like an email or a phone call or a text that said, hey, we're not doing this anymore.
Thanks, Your Honor.
I do have, and I'm pulling up the actual document now. Again, things are running slower than I'd like, but I do reflect in the system that on 5/31, the case was dismissed without prejudice.
With or without prejudice?
Without prejudice.
Oh. All right.
Okay, and the document has just loaded, and it does say that appears now the plaintiff and directs the clerk of this court to mark the above civil action dismissed without prejudice against the defendants herein named and to enter same upon the docket of the court. So everyone's good to go.
All right, let's make Mr. Mahoney's life a little easier and shoot him a copy if you can. Do you have his
Yes.
email?
Would you mind just dropping it in the chat to me, Mr. Mahoney?
Sure. And that's much appreciated, Your Honor.
No problem. All right. Jashin Un versus Avis Turner.
Good morning, Your Honor. Daniel Moore on behalf of the plaintiff, Jashin Un.
Okay.
This is a dispossessory matter. And as they're not here, we ask to strike the answer and ask for judgment. We have also moved for judgment on the pleadings, but I don't know if we need to go into that motion as they have not showed up for this hearing.
All right. So dispossessory, is this a home or?
It's a business, Your Honor.
Okay. All right. And Alley Financial versus Christopher Hudson versus U.S. Department of Veteran Affairs.
Michelle Barnes for the plaintiff.
Okay. Crystal Hudson is pro se. Anybody here on behalf of the Garnishy Department of Veterans Affairs? All right. Velocity Investments versus Charmaine Page.
Daniel Green for the plaintiff, Judge.
All right.
Did we move on from the Crystal Hudson case?
I'm sorry.
Did we move on from the
Miss Hudson? There you are. I'm sorry.
Yeah.
Okay, I didn't see you. Okay, Miss Hudson, we haven't done your case yet. I'm just calling the calendar.
Okay.
But you're here for the case, and we'll get to you as soon as we can.
Okay.
All right, thank you. And Central Auto Sales versus Anna Mae Jackson versus Anna Best Food LLC. I have that the Miss Jackson and Best Foods pro se. Best Foods being an LLC would need representation, but Miss Jackson could represent herself. Is there anyone here on behalf of Central Auto Sales? Okay, last call for Central Auto Sales versus Anna Mae Jackson versus Anna Best Food LLC. And this was for continuing garnishment. So the motion for continuing garnishment has been dismissed for want of prosecution.
Judge, who's the listed attorney for that case? I'm sorry.
Capers, Alexandria Capers.
I'm sorry, that's my case. I'm here for the plaintiff. I'm sorry.
All right, so let's hear from Jessica Wilson versus Jamario Terrell and State Farm.
Judge, before you begin, what did you have for position 6? Did both parties appear? Only plaintiff?
On position 6, the plaintiff is here and Ms. Hudson is here. The Veterans Affairs as garnishee is not.
For Charmaine Page and Velocity Investments?
Mr. Green is here on behalf of Velocity. I did not hear from Ms. Page.
Okay.
And for Central Auto, Mr. Green is here on behalf of Central Auto. I did not hear from Anna Jackson or Anna Best Foods.
Thank you.
Yes, Deputy Whitson, thank you. All right. So let's begin with Wilson versus Terrell. No, I'm sorry, Green versus Johnson. Sorry, Wilson versus Terrell. I was right.
Thank you. I'm Abigail Moody for the plaintiff. It's defense's motion for summary judgment. So do you want them to go first?
Yeah.
Okay. All right. Good morning, Your Honor. Ryan Brightman here for State Farm. I think this is a relatively straightforward question. Really, just one issue is in default. In dispute. There's no real factual questions as pertinent to our motion. State Farm is moving for summary judgment on the single question, single issue, an argument that there is no coverage for this loss under the plaintiff's uninsured motorist coverage. This accident is a single vehicle accident that involved a horse that belonged to Jamario Terrell. Apparently, Mr. Terrell's horse became loose at some point, some way, and Miss Wilson's vehicle struck the horse. As you alluded to earlier when Your Honor was calling the calendar, Mr. Terrell has not answered or made an appearance on his own behalf, but we're here just to arguing that as a matter of law, State Farm is entitled to judgment because a horse is not an uninsured motor vehicle.
Could have said it, but I wanted to hear you say it.
Yeah. So, and I'm not trying to make light of any situation.
No, I get it.
Yeah. But
because I was going to ask if this was part of a homeowner's insurance policy that I'm not aware of, or because it's that doesn't support. But yeah, so they're bringing it on behalf of the person owning the horse as a vehicle.
So yeah, Miss Wilson has served State Farm as her uninsured motorist carrier. So yes, it's a pretty straightforward question, I think. And so a few different places that we can look for a definition of an uninsured motor vehicle. First, we'd look to the statute. The uninsured motor vehicle statute tells us what an uninsured motor vehicle is, but it doesn't define motor vehicle. For a definition of motor vehicle, we could look to the liability statute, which is OCGA 3334-2, and that defines motor vehicle in the liability context as a vehicle having more than 3 load-bearing wheels of a kind required to be registered under the laws of this state relating to motor vehicles designed primarily for operation upon public streets, roads, and highways and driven by power other than muscular power. And it talks about trailers and low-speed vehicles. Now, there is case law that has, and we cited in our brief, and as did Ms. Moody, that has held that the definition of motor vehicle that I just read you is broadened in the uninsured motorist context. For example, the more than 3 load-bearing wheels. The court has suggested in the case of Hinton versus Interstate Guarantee Insurance Company, and that's cited in our brief. The court in Hinton suggested that, for example, a motorcycle only has 2 wheels, but could be an uninsured motor vehicle under the UM statute. The case in Hinton actually involved a tractor that was towing a trailer on the public highway. And so a tractor, of course, would not fall under a motor vehicle required to hold liability insurance as a regular car. But in that context, the Supreme Court held that that tractor did fall within the definition under the statute and Georgia law of an uninsured motor vehicle. So as far as that's the statutory and case law authority that we have from Georgia about what an uninsured motor vehicle is and what a motor vehicle is. There is the case of, Georgia Farm Bureau Insurance versus Claxton, where the Court of Appeals was faced with a factual scenario after a parade. A couple of gentlemen were driving their mule-drawn carriage, and the Court of Appeals there found that the mule-drawn carriage was not an uninsured motor vehicle. And The only other case I could find on point with involving animals is another case would be Persuasive Authority from Kentucky that found also a horse-drawn carriage, whether it's a mule or a horse, was not an uninsured motor vehicle. I understand. Yeah.
May I ask, there was only the horse, there was no structure attached to the horse, no vehicle, no trailer or anything.
Yeah.
Horse wasn't pulling anything.
So in the case of the Farm Bureau case, the Court of
No, I
Appeal,
meant in the present.
in our case, no, Your
Okay.
Honor, it's just the horse.
Okay.
No trailer, no other structure attached to the horse. So yes, in the Court of Appeals case involving the trailer, part of the argument was about whether the carriage qualified as a trailer. But there was no such issue in our case. So I understand that the plaintiff in response argues that the UM statute is remedial in nature. The courts have held that it's to be interpreted in a way to protect the public. However, I'd argue that there still has to be the words still have to have a meaning. The commentator Jenkins and Miller, they have referred to UM coverage as insurance against lack of insurance. So even
that's the broadest interpretation of it.
Right. So here there's no law that would require it might have been a good idea. And who knows? We haven't been able to speak with Mr. Terrell to see if he had a homeowners or umbrella policy that might cover him. But there's no legal requirement that people hold liability insurance on their horses. So this isn't a situation where the UM coverage is essentially insurance against lack of insurance.
All right. The closest, I guess, scenario that I could figure that happens commonly is if someone's car gets hit by a deer.
Yeah. Yeah.
They come out of nowhere. It's an animal. They're definitely not insured, but there have been no cases where someone can claim from their UM policy coverage for that type of scenario, is there?
No. So, that's what I didn't want to, again, make light of the situation, but
I'm not making light.
It does, you wonder if we accept that a horse in this case is a motor vehicle, then, is a deer, is a cow, is a goat, is a dog, is a cat, is a squirrel. If somebody just sees the squirrel in the road and swerves into a tree, is that squirrel an uninsured motor vehicle at that point? So in the response, the plaintiffs argue again for the remedial nature and protection of the public for the UM statute. They argue that the horse was could be used like a vehicle. Mr. Terrell apparently may have ridden his horse to a restaurant that evening and tied it up. Not well, apparently, but tied it up. So the language that the plaintiffs focus on in Hinton is that an uninsured motor vehicle is a motor vehicle that is not designed primarily for use on the public roads and are not required to have liability insurance, but which, at the time of the accident, are being operated on the public roads like a vehicle designed primarily for that purpose. So even if we go with that definition from Hinton and accept the remedial purpose, the entire reason that there was an accident here is because the horse was not being operated, at the time of the accident. That's the part of the Hinton language that the plaintiff leaves out or doesn't recognize in their argument. So for those reasons, we would ask the court to find, as a matter of law and a matter of contract, that State Farm does not owe coverage to Ms. Wilson for this loss and issue judgment in State Farm's favor. Also included, I did not go into the policy language definitions, but the policy language definitions as well, I'm sure Your Honor can imagine, are do not include animals and horses in the definition of cars or motor vehicles or uninsured motor vehicles. And all that has been included and attached as a certified copy of the policy to the brief.
Okay. All right, Ms. Moody?
Yes, Your Honor, thank you. So as the defense counsel said, this accident was back in February of 2024. And my client is basically traveling along a public road, Anvil Block Road. And what happens is a saddled up horse comes out and hits her car. She tries to avoid it. And as defense counsel also pointed out, we don't know a ton about the circumstances. We know from the accident report, and then the defendant is in default. And so, of course, the allegations in the complaint are considered true. But what we have gathered is the defendant rode this horse up to a place called Aquatic Blue, which is a restaurant bar, from what I can tell, tied the horse up outside. And then at some point, we don't know when, the horse gets loose and comes into the roadway. Pretty extensive damage here. The vehicle, I don't know if I can share my screen, but
You may.
let's see if I can see it. How do I do this? Let's see. Sorry, Your Honor, I'm trying. Let's see. This is what her car looks like, just so you can have an idea. You got that? Okay. And so yeah, it's a pretty extensive damage. And it's about $63,000 in bills. She has dental work, she has glass, all that stuff. And so what happens is, of course, the defendant doesn't answer, and we've been able to find no other insurance for this. And so now UM is, in our case, what we consider up. And so State Farm is basically saying that the horse is not an uninsured motor vehicle, and therefore no coverage. And as counsel stated, the two arguments that they're using is, one, livestock are not uninsured motor vehicles under Georgia law, and second, basically the policy language. And so before I go into why I think he's wrong, I would first state, the summary judgment standard, which is that when the facts are viewed in light most favorable to the non-moving party, which is us, plaintiff Jessica Wilson, there must be no issue of genuine issue of material fact, and the fact must support judgment as a matter of law. And here I think that there is at least an issue. Now, what that issue is, but it has to be no issue to grant summary judgment.
Ms. Moody, if you can't articulate an issue, then how am I to assume that one exists? So here's where I am. The reason I asked about the deer and the reason I asked about structures attached to the vehicle, to the horse, is if you're telling me he's pulling a trailer or a wagon, then I can say, okay, it might not be motorized, but it is a vehicle. So that may be something that a jury, and I'm willing to take my chances with the appellate court. Not that I'm scared of them or anything, but at that point it's worth it. But at this point, I've asked if there was a structure attached to the horse, no structure attached. So I've asked about a deer, like if a deer comes out, it's not owned by anyone. If it hits your car, it can do the same amount of damage to personal and property to personal injury. But there's no way to sue a UM carrier for that.
Yes, Your Honor. And so what I would argue in defense of this, what I would articulate is this. So first of all, the UM, as I said, is supposed to be remedial in nature, right? And in that case of Hinton that he's talking about, there's two prongs that they get. They say there's at least two prongs that have to be included as what is a motor vehicle. And the court clearly says at least two. So they don't say exactly what those are, right? But the second prong, which is the one that, I keep on harping on, is the one that says that motor vehicles have to be included, motor vehicles that are not designed primarily for use on public roads and are not required to have liability insurance. And then, which at the time of the accident are being operated on public roads like a vehicle designed primarily for that purpose.
Which I would assume would be a dirt bike or an ATV.
Well, so I would say operated for that purpose. Okay. So when we say that someone took the vehicle, took the horse, saddled it up, and took it just as you would a vehicle to a public place to have dinner, that is using it as a vehicle. I also have one other thing to show you, Your Honor. from the, if I can try to share it again, from the, if you see, hang on, I'm sorry, I'm trying to do it. Share screen. Why is it not going? Let's see, I'm sorry. Here we go. This is where Your Honor, this is where the aquatic blue is. And this is somewhere around Boulder Crest is what we have the address for the defendant. We don't know how he got there, but clearly to get there, you have to cross some sort of a public roadway. So is it being operated in a public roadway? Yes. I mean, I would argue that yes, there's at least a genuine issue that it could be considered a vehicle in this. It's literally a vehicle transporting him into the lounge. So, I mean, that's how it's being operated. It's different than a random deer coming out, because a deer isn't that's just a random deer that's coming out into roadway, or cow. This is something that is being used as a transportation in this case. Like the horse was taken as a vehicle to take the person, as a car would, to this restaurant. And so I would say that, that can fall, there's at least an issue that falls within the second prong. And then I would say in that Hinton case, again, the court articulates that at least those two categories. So even if you didn't think that matters, the court says at least. So I would say, again, that there's a genuine issue there. And then for the contractual part of it, I think that the contractual part is not as clear as Mr. Brightman makes it sound. It's clear that the uninsured motor vehicle in the policy, which we have as well, is defined as a land motor vehicle. But that term in the policy is not articulated. So hang on one second. So what is articulated in the contract is the term car, which is in one place. It's on page 4 of that policy, where it talks about the 4 or more wheels. And what Mr. Brightman wants you to do is use the term car in the term of, basically transport that into the uninsured motorist definition, but that isn't there. In the uninsured motorist definition, which is, I can share that as well. The uninsured motorist definition, there's no place that it says car. And so I would argue to you that if they meant 4 or more wheels needed, then they should have used the term car. In this uninsured motor vehicle coverage, the term car is used in different parts of this language, and the property damage and the insured definition, but it is not used when it says uninsured motor vehicle. We only have land motor vehicle. And so because it does not have the term car, and yet car is articulated elsewhere in the contract, I would argue that there is some ambiguity there. And any ambiguity in a contract, of course, is strictly to be construed against the drafter, which is State Farm. So I would argue again in that there's a genuine issue of material fact there. It's not enough to grant summary judgment and read my argument. And so for both the horse under Georgia policy and law and under the contract, I would argue that there's a genuine issue, and that I would ask the court to deny summary judgment.
I did notice that you're staying away from the word motor.
Your Honor, motor, we talk about like horsepower as motor, and I understand I understand. I can't argue to you that there's a motor on a horse. I mean, obviously I can't argue that. But what I can say is that, it's being used as a vehicle in the sense.
Your Honor, if I could just very, very briefly respond. I think we've covered most of the issues, but just in response, as far as land motor vehicle is the term used in the UM section of the policy, I think there's no ambiguity. The words have to have meaning. If it's not defined, you look to its plain meaning. A motor vehicle is a vehicle with a motor. Whether it has 4 or more wheels, 1 wheel, whether you 2 wheels, something with wheels and a motor. Lastly, to the point about the Hinton language, and the Hinton language says that it's being operated at the time of the accident. If this were a case where Mr. Terrell were riding his horse from his ranch to the restaurant to the bar and got in an accident. I still don't think it would be a motor vehicle, but we'd be closer to the Hinton definition than we are here. That's very different. It was not being used as a vehicle at the time of the accident.
All right. We will look more carefully at all of these definitions and give you an order.
Okay.
Thank you, Your
you.
Honor.
Thank you, Your Honor. May we
All
be
right.
excused?
Yes.
All right. Thank you. Bye.
All right. The dispossessory Unv Turner. Is everybody ready on that?
Yes, Your Honor. I guess we would move to strike the answer that was filed in this matter as, but this is a dispossessory of a business. I have the property manager with me today. Would you want the whole spiel, or can I just give you the arrearage and present the order, or what would Your Honor prefer?
Okay, so let me call one more time because I missed Miss Hudson on the other one. So I want to make sure I don't have Miss Turner on here and I don't know it. So Avis Turner or Avis Turner. All right. All right. So you have your witness here.
Yes, Your Honor.
Is this Miss Peterson?
Yes, sir.
Raise your right hand.
Actually, it's Miss Boyle, I believe.
Oh, I'm sorry. I see Haley Peterson.
Maybe she could explain.
My maiden last name.
All right. Raise your right hand for me. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes.
All right. You can put your hand down. Mr. Moore, your witness.
So, Ms. Boyle, can you please tell me where you are currently employed?
The shopping center group.
And what is your relationship to the plaintiff?
I am the property manager that represents this shopping center for the plaintiff.
Gotcha. And do you handle and what does that entail?
It entails managing the client-tenant relationship, financials, collections of rents, going through that legal process if they don't pay, if they do pay, handling the property overall.
And you're the custodian of the plaintiff's business records regarding delinquent tenants' accounts?
Correct.
Okay. And the defendant in this case is a tenant of the plaintiff, correct?
Yes.
Okay. And per the lease agreement, they were required to pay rent to the plaintiff?
Correct.
And they have not paid rent to the plaintiff, correct?
Correct.
And plaintiff has made a demand for possession to the defendant?
Yes.
Okay. And according to the business records of the plaintiff, can you tell me what the total arrearage or delinquency amount is today?
As of today, it is $17,602.80.
Okay. And is that all you're asking for today?
Yes.
Sorry. And in addition to that, we will be asking for attorney's fees under 911, or excuse me, under 13-111, correct?
Yes.
Okay. As well as costs.
Correct.
And then we were asking for possession of the property pursuant to the lease in Georgia law, correct?
Correct.
Okay. And Your Honor, I could present the ledger as a document, but
Okay. Just how many months were they delinquent? Was it one of those where hold on, was it that, or was it they partially pay and pay
they have
a
not
little
paid
bit, or
a single payment?
Okay, then how many months was it that they were in occupation but delinquent?
The lease date is September 2024, so September, October, November, December, January.
All right.
10 months, is that right?
Okay. All right, so based on the sworn testimony of the property manager, the award will be for $17,602.80 plus attorney's fees as pled in the documents plus costs. And if you will present the order, or if you've already presented it, then I have it. But if you'll present the order, Ms. Powell will manage that for you.
Thank you. Just send it to Miss Powell or
Ms. Powell.
okay.
Yeah.
We'll ask her for it. I do appreciate it. Thank you, Your Honor.
No problem. Thank you.
Thank you.
Have a good day.
All right. All right. So then next case on the calendar is Ally Financial.
Good morning, Your Honor.
Good morning. So this is Ally Financial, Crystal Hudson, and the U.S. Department of Veterans Affairs.
Good morning.
Good morning. So, Ms. Barnes, you're on here on behalf of Ally Financial, correct?
Yes, Your Honor.
All right. Let me know what's going on.
This is a defendant's claim. So if the
Okay.
defendant would like.
Ms. Hudson?
Oh, it's about the wage garnishment, that I will not be able to, I can't get my wages garnished. And this
Okay.
is, I'm the co-borrower of this
Hold
account.
on. All right. So, Ms. Hudson, are you challenging the judgment, like the fact that they have a judgment against you, or are you just saying that this is something that can't be done because it's a government agency?
Not that it's a government agency, it's just I can't afford it. I already have a government thing garnishment coming out of my check already. So
Okay. So you're saying that I'm sorry, I'm trying to understand your argument.
well, that's I don't even know what's going on. When I got the garnishment from my employer, it said that I can challenge it to show that I have something already coming out of my check from the government. So to have two government garnishments, I am able to challenge it that I do not get garnished.
It's attached to her federal thrift savings plan, Judge. It looks like there was a loan that she used her federal employee thrift saving plan for, and she's on like a 5-year payback plan through her paycheck, I think is what it looks like.
Yeah, so what she's arguing is, and I had to look it up because I wanted to make sure the percentages hadn't changed since I was last educated on garnishment. But what she's arguing is that she has this will exceed the maximum amount of wages that can be garnished. So federal law limits garnishments to 25% of disposable income, or the amount by which disposable income exceeds 30 times the federal minimum wage, whichever is less. So Miss Hudson appears to be making that argument. So Miss Hudson, what is your what is it your gross amount that you make per month?
Per month, I think the gross would be about that. My take home was like $1,000. My take home for gross.
No, your gross would be what you're paid before they take anything out. Your net, or what you take home. So
Okay.
after they take everything out, what would your net be? But I'm asking what your gross is. What is the amount that, huh?
2,100.
2,100.
Your Honor, if you don't mind,
Yes, ma'am.
it's say the garnishee has filed an answer with the court, and you should see that per pay period, the gross is $2,422.48.
Okay.
And that's per pay period, Your Honor.
Okay. So Miss Powell, can you put up what the garnishee filed because I want to see if they have this other debt that on there, the other thing that's being taken out.
Yes, ma'am. The image is loading up. Just have it in a couple moments.
Okay. So also, as I understand it, I'm not sure if this is cumulative, meaning if you're paying another debt, that another judgment can come in. Like I'm not sure if we're talking about an individual debt, debt, in an individual judgment can't be more than 25% versus cumulative judgments, meaning if you already have some money coming out, then can a new creditor come in and take out money that exceeds the 25%, but it's not 25% based on what they're bringing in. It would be 25% cumulatively. So that would be an issue also. All right. Okay, so this is the promissory note. What I was looking for is if she has anything from her employer saying what's being taken out.
Okay, let me share my entire screen and then maybe you can see the record.
Okay.
Okay, so going back to Zoom. And then
Ms. Barnes, how much is the total amount of the loan that you all are asking for?
The judgment was $13,176.69, but the remaining balance, Your Honor, is $9,788.05.
Okay, and do you know, have you received anything from the garnishee? Okay.
Yeah, it looks like we've received some funds. Second. No, we have not yet, Your Honor. We've
Okay, so nothing's been received?
No, Your Honor.
All right.
Two
And
deductions was taken out of the last two pay periods. One was for $480 and the other one was for $390, I believe.
okay,
I
you
believe
said
that's with the court.
okay, so before they get them, Ms. Hudson, we hold the funds, so they have to request that they be released to them. So what I'm asking is, do you know how much is being taken out from the other loan that you had?
$244.
$244?
Yes.
And that's from the other loan, not this one.
Yes.
Okay. And and you make $2,422, did you say a month?
Bi-weekly.
Okay, every 2 weeks.
Do you want me to keep sharing my screen, Judge, or are you getting the information that you need?
Hold on. I think I'm good.
Okay.
Okay. All right. Ma'am, it looks like currently, if you did it per week, the the amount coming out per week, because you said $244 a month is coming out. So the amount coming out of your weekly check would be about 5% of the weekly amount. So we haven't gotten to the 25% yet. And even though I know it is a lot, because of what you are making, I don't think we've reached the 25% threshold that would prevent them from collecting on their judgment.
Okay.
All right.
I just can't, like, my livelihood, I cannot afford to have that coming out of my check. Like, I don't know if they even reached out to the co-borrower on this account and did his wages or anything, but I can't afford it to come out of mine.
Ms. Barnes, you can answer that if you want. I'm not sure that you're required to.
Your Honor, I have no response to that.
Okay. Ms. Hudson, unfortunately, and I pray that you didn't co-sign something for somebody, but unfortunately, if you are attached to the debt, then the creditors can go through whatever legal means to recover the debt. And it doesn't mean that even if you have another person who's borrowing with you, nothing requires them to get it from one person or the other. They may go after one person because that person has the job. It just depends. But unfortunately, as much as it's a hardship, you have not shown that it exceeds which it's not just the federal level. Georgia follows the federal rule with respect to that. You haven't shown that the amount coming out of your check is more than 25% of your weekly gross.
Okay.
All right. So you may want to talk to the co-borrower and see if they'll help, because I understand it is going to be a hardship for you.
Okay.
All right. So the traverse is denied in this case.
Thank you.
Thank you, Your Honor.
You're welcome.
This is my last matter. May I be excused?
You may. Thank you. All right. So the next case on the calendar is Velocity versus Page.
Your Honor,
Mr. Green?
yeah, Judge, that's my case.
All right. So Velocity Investments versus Charmaine Page. When was Ms. Page served?
Judge, she's filed an answer in the case, and this case was dismissed, but I filed a motion to vacate the dismissal. And so we're back on. We would, if she's not here, we would seek a judgment in the amount of $1,989.
Okay, how are you seeking a judgment for a case that was dismissed? So this is the motion to vacate. I'm sorry?
You, by your order, I'm looking at your order. You already vacated the dismissal.
Okay. Is this the one where neither party showed up?
I believe back in March 7th, neither party showed up. I filed a motion to vacate the dismissal. According to your order setting the hearing, you vacated that dismissal.
All right, let me go back.
The defendant might have appeared the first time, Judge, but it was the attorney had a scheduling issue that happened, and we vacated the dismissal.
Okay, did Miss Page get notice of this hearing?
She was sent notice. Let me make sure that it wasn't sent back for any reason. Zero 1193. Okay. No note that her notice was sent back, Judge.
All right. All right, so go ahead, Mr. Green, and tell me what Velocity is seeking.
Yeah, Judge, we're just seeking a judgment for the principal amount of $1,989.99 and $269 in court costs.
Okay, and this is on a loan, personal loan?
It's a credit card, Judge. It was a credit card with Mercury originally.
All right. The defendant was given notice in this case. She did answer, was properly served and did answer. The court had an initial hearing where neither party appeared, but it was later determined that the attorney had a conflict. The case was rescheduled for both parties to get notice and both parties to appear. Ms. Page, Charmaine Page, has not appeared. Velocity Investment is seeking a default judgment in the amount of $1,989.99 plus $269 in court costs. Court is going to grant that judgment plus court costs.
Thank you.
All right, and the last case is Central Auto Sales versus Anna Jackson and Anna Best Foods. And Anna Jackson is pro se, but Anna Best Foods is listed as pro se. As a company, it's required to have representation. So at this point, the Anna Best Foods is in default and will go forward on Central Auto Sales versus Anna Mae Jackson.
Judge, could you kindly give me the case number for that one real quick?
2025 CV 00350.
Thank you, Judge. So yes, we served the garnishee with the garnishment, and we haven't gotten an answer. So we would move for default against the garnishee, and we can either prepare a motion to that effect, or I believe we may have already filed a motion. So we're just asking that that order be granted.
All right. So you have a judgment against Anna Mae Jackson. The company, Anna Best Food, is the garnishee. They were given notice to appear, did not appear. They're not represented by an attorney, and they haven't filed anything in response to the garnishment. Is that correct?
That's correct, Judge.
This was on the docket because the defendant, it looked like the defendant filed a claim into the into the docket. But also her defendant claims form was blank. So if we're not hearing the defendant's claim form because defendant did not appear, it didn't look to me like there was anything else that was ripe for this case for adjudication.
Yeah, okay, so Judge, yeah, so if the defendant is not here, I just ask that her claim be dismissed for want of prosecution.
Mr. Green, is this actually your case?
It is, Judge. I'm trying to text back with our office, and they're saying they didn't get notice of it, so I'm saving it for them.
Okay. All right, so the defendant's request to have their claim form reviewed or whatever they were asking for is going to be denied. So the defendant's motion will be denied in this case.
Thank you. Your Honor, that's all the business I have before you. May I be excused?
You may.
Thank you.
All right, so the 11 o'clock calendar.
Your Honor,
Yes.
this is Emery Potter. My sound was not working, and I've been frantically working at that for quite a while. I'm here on 2023 CV 1380.
Okay, can you give me a name?
Flexibility Capital versus Prince Electrical.
Okay, I haven't called the 11 o'clock calendar yet.
Oh, I'm sorry, Your Honor. I'll sit down
That's
and be
okay.
quiet.
I just finished with 10 o'clock. I'm going to call it now. All right, no problem. All right, Joseph Davis versus Oxford TH Partnership.
Good morning, Attorney Sarah Malkin on behalf of Oxford Townhomes.
You're on behalf of Oxford, I'm sorry.
Yes, it's an appeal, so I guess the defendant in this case.
Yeah, so Joseph Davis, Mr. Davis, Joseph Davis, I've called him a couple of times. This case, I believe, was on a previous calendar, and it was dismissed for want of prosecution.
I have not received notice of it being on a previous calendar, Your Honor, but it's an appeal from a consent agreement, so we are arguing that there is no right of appeal.
There's nothing to, right, okay. Yeah, so Mr. Davis's appeal will be dismissed.
Thank you, Your Honor, and that concludes my business. May I be excused?
You may. Thank you.
Thank you.
Ahmed Kamara and Ajatu Jola versus Sean Doe, Ernest Turner, Atlanta Realtors LLC, and Atlanta Realtors LLC again.
Good morning, Your Honor.
Good morning.
Jermaine Austin here for the plaintiffs.
Okay. Anyone here on behalf of defendants Atlanta Realtors or Ernest Turner? All right, were the defendants served in this case?
They were, but I am going to double check, make sure nothing was sent back.
Because I have a, yeah.
Yeah, I don't have anything that says that anything was bounced back for any reason.
Okay, Mr. Austin, tell me what's going on in this. This is an action on a contract?
Yes, Your Honor. It's an investment contract. And pretty much, my clients made a $200,000 investment to the defendants, and there were promises along the way to pay back. And the excuse.
So I'm looking at it and it says realtor. So was it into the realty company or was it on it by buying or investing in property?
It was. It wasn't buying and investing in real property. It was an investment in vehicles and other goods.
This is going to be complicated. All right, Mr. Austin, give me a minute. I'll be right back. Okay, now my iPad is going goofy. Hold on. Oh, there we go. All right, next is LVNV Funding LLC versus Wendy Powell. All right, y'all can hear me, right? LVNV Funding LLC. I have Kyle Floyd as the attorney versus Wendy Powell. Going once. All right, dismissed for want of prosecution. Flexibility Capital Inc. versus Prince Tyrone Easton and Prince Electrical LLC.
Henry Potter for the plaintiff. We're proceeding on an affidavit for the damages against Prince Eason.
All right, anyone here on behalf of defendant Prince Tyrone Easton Jr.? All right. Next is Abedi.
I'm sorry, Judge Hayward.
Yes.
I'm sorry, I touched the wrong button and I disconnected from you. I'm Wendy Powell. Can you hear me?
I hear you just fine.
Okay, I'm here. I'm sorry.
All right. So Ms. Powell, LVNV Funding LLC. No one's here on behalf of LVNV Funding LLC. So unless you filed something, their motion or whatever they were asking for is dismissed.
Oh, thank you. Thank you. Thank you. Am I free to leave?
Powell?
Yes, ma'am.
That doesn't mean that they won't pursue whatever is going on. So it might be your best interest to try and talk to them and see if, whatever y'all can work out so that this doesn't come back through the courts. It's always better if you can work something out that accords with your ability to pay,
yes,
as opposed to me giving a judgment and them, kind of having the upper hand with respect to how they collect.
Okay, I appreciate that. Yes, ma'am. I'll reach out to them.
All right. Take care.
Thank you.
You're welcome. All right. And next is Ahmad Al-Abedi and Hayat Daman versus Ace American Insurance.
Good morning, Your Honor. This is Harold Spence and Karima Alameen for the plaintiff.
All righty. Anyone here on behalf of the defendant? You all are representing both defendants. So Mr. Spence for Mr. Al-Abedi and Ms. Amin for Damon. Is that correct?
We're both jointly representing both defendants, Your Honor.
That works. And Ace American Insurance. Is there anyone here? I have Mr. Mark Bardak for Ace American. Have y'all heard from him, or is there any indication that he has a conflict, Ms. Powell?
We have not heard from him, and he has not responded to recent communications from me. And we'd ask that their motion be dismissed for want of prosecution, Your Honor.
Okay. All right.
I'm looking to Judge. Do you mind calling out the case number to me, please?
Sure, no problem. It is did the wrong. It is 2021 CV 00245.
Okay. I don't have anything in my email about
All right.
it. And also, oh, sorry, no, that I checked one place, but then checking another place. Today's date is the 4th of June.
Yes.
I don't see any conflicts in the system.
All right. So their motion will be dismissed for want of prosecution.
And Your Honor.
And the plaintiffs did not have anything pending. Is that correct?
We simply asked for attorney's fees because we regarded this motion as frivolous because the court had previously considered a motion making a similar legal argument. In filing this new motion, the defendants advanced no new case law, advanced no new legal analysis. They didn't try to refute in any way any of the court's legal findings from the previous order. You'd expect that if they thought that you were wrong, they would have tried to have pointed that out. Not a single word in their filing was devoted to trying to establish that you were wrong, that you misapplied the law, that you misinterpreted the law. And we think it was a totally frivolous filing, Your Honor. It shouldn't have been filed, and we shouldn't have had to have responded to this.
This is the one where they have multiple filings, where we have multiple filings, I think.
Yes, Your Honor. We have a case pending in Gwinnett County against the trucking company and the truck driver.
All right. So what amount of damages for attorney's fees are you pleading based on this filing?
We would seek $1,000 in attorney's fees, Your Honor.
All right. I did note that there didn't seem to be any new ground covered in this motion. So the court is going to grant you the amount of $1,000 in attorney's fees based on the frivolity of the pleading.
Thank you very much, Your Honor.
All right. And go ahead and give me an order.
And may
we be
excused, Your Honor.
Yes, you may be excused. Thank you.
Thank you. Have a good day, Your Honor.
Thank you.
Thank you.
Thank you.
All right. And next on the calendar is Discover Bank versus Coleman. Discover Bank versus Sherry Coleman.
Good morning, Your Honor. Mia Waters here for the plaintiff.
All right. Ms. Coleman, did she ever answer?
No, we did not get a response to our motion for summary judgment.
All right. And I will be back to you in a moment.
Thank you.
Sedarius Whidbey versus Derek Marshall, Grange Indemnity Insurance, Doe's 1 through 5, ABC Corporations 1 through 5, Stop and Go Loading and Unloading versus AICA Orthopedics. Okay, this motion was withdrawn and excused. All right. Fazito Chancey versus Cedric Hudson and Property Rental Company.
Good morning, Your Honor. Josh Samuels for the plaintiff.
Good morning. And I thought I saw a Cedric Hudson.
Yes, ma'am, I'm here.
All right. Mr. Hudson, is anyone representing your property rental company?
I have no clue.
They're separate defendants, Judge. That's his landlord.
Okay. All right.
But they are also in default and no one's appeared for them.
Okay, no problem. And next is Devontae June Taylor, Denise Tuckenberry versus Michael Corday McKinney.
Good morning, Your Honor.
Good morning.
We're both here.
All right, anyone here on behalf of Mr. McKinney?
No, he never answered.
All right, and that's it. All right, so Kamara, Jill, give me a minute on that one because I think that's going to be a little bit complicated.
Okay.
Flexibility Capital versus Prince.
All right, Emory Potter for Flexibility Capital, Your Honor. Pursuant to our affidavit in January 22, Prince executed and delivered a future receivable sales purchase agreement for the price of $14,000. But it was to be paid back a remittance of $162.22 a day. And the default price would be liable for all collection fees, expenses, costs. Prince Easton Jr. executed a personal guarantee of the debt. And that the time it was breached on or about February 22nd, 2022. At the time the final payment was received, the balance owed on the purchase amount was $17,520.04. My client has been damaged in the amount of $17,520.04. And as such, that's how much is owed by the defendant in the principal amount. We're also asking for prejudgment interest in the amount of $6,531.85 and reasonable attorney's fees of $2,343.39. Those attorneys fees are under 13-111 and were computed using the formula therein of 15% of the first $500 and 10% of the excess. And Shalonda Barnes, my paralegal, should have forwarded you an proposed order.
Okay. So this is so you said he was supposed to pay back $160.22 a day?
A day, yep. This is a merchant cash agreement.
Yeah.
So yes, it's by automatic ACH, and then he stopped the ACHs.
Okay. All right. So $117,520.04 is the principal amount owed currently. And then there's prejudgment interest, pled in the amount, I think I got the number right, $6,531.
Yes, and 85 cents.
And 85 cents. And then attorney's fees, $2,341.39. Did I get that right?
$43.39.
I'm sorry, I was writing really fast.
I'm sorry, I talked too fast, Your Honor.
That's okay. All right. So, and did you have any other amounts that I may have missed?
No, Your Honor, that's the only amounts being sold.
All right. So we probably already have your order. We'll go ahead and get that signed. If we don't, we'll send you an email and we'll get one. Okay.
I appreciate it, Your Honor. May I be excused?
Okay, sir. Thank you.
Have a great day. Thank you.
Reminder never to sign one of those merchant agreements. Woo! All right. Next is Discover versus Coleman.
Good morning, Your Honor.
Good morning.
So this is a motion for summary judgment. On December 6, 2020, the defendant opened a credit card, and she made use of this card over a number of years. She made payments on this card over a number of years. And on or about August 31st, 2022, she made her last payment of $134. And as of now, she has not made another payment since then. So we are now showing an amount due of $7,014.86 plus court costs of $336.66 for a total of $7,351.52.
All right. And those are all the amounts pled?
Yes, ma'am.
Okay. So the court finding that Ms. Coleman is in default, and the evidence presented shows that she did actually open the account, use the account, make payments on the account, but after the point where she stopped making payments, she became in debt in the amount of $7,014.86, plus $336 in court cost and $36.66 in court cost to bring this action. So the court will grant the amount of $7,351.52.
Thank you, Your Honor. And I do believe that the proposed order is included with our motion.
Yes, ma'am.
All right. And that is all of my business for today. May I be excused?
You may.
Unless I missed it, I don't see the proposed order with the motion. Do you mind just emailing it to me and I'll chat you my email?
Yes, that'll work.
Thank you.
All right. All right, Chancey versus Hudson.
Yes, Your Honor. This is a dog bite tort claim, and this is a discovery motion to strike Mr. Hudson's answer. I don't want to rehash the brief because I think we kind of go through the timeline on that already. But essentially, it's no responses to written discovery, 3 depositions missed. Well, sorry, excuse me. 2 were attended, but both had objections to providing any information to us. The 3rd one was missed after we obtained an order from you ordering Mr. Hudson to deposition. It's a 2022 case. It's been pending for almost 3 years now. There's no insurance. The landlord's defaulted. And so we think the only sanction that cures the prejudice here and allows us to move forward with a damages hearing is to strike the answer. Otherwise, the other sanctions available, like awarding attorney's fees and things like that, Mr. Hudson's probably not going to be able to pay those, and they're not going to put us in the position that we would have been in if the discovery was had. So I know it's a harsh sanction. I know that he is pro se, and that's why we're not asking for fees in addition to striking the answer. But when you exercise your right to represent yourself, you're treated to the same standards that attorneys are. And if it were my client that did all of this, that, you know, as we laid out in the brief, I don't think you'd have a problem dismissing our case for want of prosecution. So that's why we're asking for that sanction.
All right. So, Mr. Hudson, you understand what Mr. Samuels is asking me to do?
No, ma'am.
Okay, let me explain it. So this is the issue with representing yourself, especially in a civil context, because it is very, very technical. But when a civil case is filed against you, and you have you answer that case, that means you're putting yourself into the litigation, which means that they have obligations to you, you have obligations to them. Part of that obligation is under discovery, which means you will exchange information, and there are rules to it. But they get to send you questions, they get to send you statements that you have to verify, they get to have depositions where they ask you questions regarding anything that could lead to information that might be relevant and produced at trial. And so all of those things, they have that responsibility and you have that responsibility. My understanding is that they have tried to engage in discovery with you and you have been what is essentially non-responsive. They've set up depositions and you've refused to answer or provide relevant or information that might lead to information that is necessary for trial. And so with that being said, I can't treat pro se litigants any differently than I treat people who are trained in the rules of procedure, evidence, who are attorneys essentially. So if you put yourself at a disadvantage when you don't have an attorney, and I know attorneys are expensive, but what we do, as attorneys, is we understand the rules. And so we know how to guide you by the rules. And my mom's an attorney and she says a lot of her clients say to her, well, it's just talking. I mean, I know how to talk, but do you know how to say the right words? Do you know?
Well, see, I really never understood when he was calling for the dispositions. I never really understood what disposition was. I never went through it, never had to deal with it. I thought once I sent the copy of the video to the courts, because he was asking for a copy of the video, well, I turned it over to the courts. It's at the courthouse. I don't have a copy of the video. The video is literally, when I answered to their question, I figured once I answered their question and answered it with the video, that the courts would give him the video. I didn't know that I had to provide him a copy of the video, but the video is at the courthouse in the file.
Unfortunately, Mr. Hudson, that's not how it works. So the courts are the neutral party. We stay out of it as much as possible. I hear as little as possible until you all come to me for either a motions hearing or a trial. And so all of the responsibility for the litigation of a lawsuit is between the parties. So Mr. Samuel says he's done his part, but you failed to do your part. And he's asking me now to change your posture in the litigation. He's asking me to remove your answer and put you in a default. And if I put you in a default position, that means you have not answered. There's no dispute. Mr. Samuels will win by default. His client wins by default, and he will ask me for a judgment. All he'll have to do is prove the damages for the judgment. Now, you still have the opportunity to weigh in on the damages phase, if I were to do that, you could say that I've paid this or I challenge this as with respect to damages. But essentially, if I remove your answer, he wins the case. I don't mind explaining as much as I can, but the problem when you represent yourself is you don't understand things like the responsibility to participate in discovery, what a deposition means and what it requires of you, what it means to turn over discovery to the other side. So the courts, you don't have to, you can file discovery with us, but the most important part is exchanging discovery, sending it to the other party, them sending you what you asked for.
Okay. Well, I explained to him that I didn't have it. I explained to him that it was at the courts. When we went in the first deposition, I explained to him that I didn't have a copy of the film. It was at the court. I don't know how to go back up there and get it from him. What do I go ask him for it back and then send it to him? But I don't know how to go up there and get it. I turned it in when I turned it in with the answer. I figured once I answered and gave them a copy of the film that was me answering him and giving him what he needed. Now I understand you're telling me now that it don't work like that. I do understand that now. But that's how I figured that was my answer was answered, because if had I known it, I would have kept the video for myself, and then I would have been able to present it had I known that's how it goes. But I didn't know it, and I understand that you're explaining it to me now. But when he was asking me questions, I was thinking like he was just, I don't know, just trying to build the case, really, honestly. So that's why I refrained from giving him any of the information, because I felt he was trying to build a case. It was like being attacked. So that's what really kept me from even talking to him, period, at all. But it is, like I said, it is a video on file that's showing where the Chancey did whatever he did. I'm not saying that the dog did not bite him, but I'm saying that he was aggressive towards the dog. That's what shows on the video, that he was aggressive towards the dog, and that's what made the dog attack him. So I figured once I sent that into the courts, and one say this case was dismissed in another court. It had been dismissed, but I understand.
Mr. Samuels, do you have the video that he's talking about?
I don't, and I'm concerned that if it's been spoliated, even if unintentionally, that's really going to prejudice my client's case at this point. It's direct evidence of what happened that day.
Okay, I'm not sure where he said he brought it down to the court. I don't know what that means. I don't know what form it was in.
Okay.
I have every confidence that our state court clerk is stellar when it comes to preserving documents and submissions. Even if they're in video form, she will take whatever they give her and maintain it in the way that it was given. However, I don't know what was given. There's no way for me to know that. If you can access whatever the clerk has, that's fine, but I'm not sure how this all went. But like I said, I don't have any idea of how this all kind of went. But unfortunately, Mr. Hudson, the part that I guess is most important is I can't treat you any differently than I would treat Mr. Samuels' client if he did the same. So if you sued Mr. Samuels and he said, my client's not answering any questions, I'm not participating, and I've had some attorneys do that. We've had to walk them back to what the rules say. But I can't, because you're pro se and you didn't know, I can't use that as an excuse to not respond to the motion that Mr. Samuels has had.
Okay.
Okay. All right. It's not, I don't know. It's hard, I know, because what people see on TV about how cases go, what they understand from the barbershop. My husband and I joke all the time about barbershop law versus actually law. And at some point, we're going to talk about that. I may do a podcast when I retire, because what they tell you in the barbershop or wherever you get information about how a case goes, it is so different from the way a case actually goes. And so, yes, Mr. Samuels was attempting to get information for his case, but you have the same right to get information to defend your case. And you got to know how to do that. So at this point, Mr. Samuels, I'll go ahead and grant your motion. So both Mr. Hudson and the court, I guess the landlord are in default. I would like to place the damages hearing on another motions date because Mr. Hudson does have the opportunity to challenge any damages that you assert from your client. If he has documentation, if he has anything, video, even if he wanted to present it, or anything else with respect to the damages hearing, then I would prefer to have it at a different time.
Yeah, I think that's fine. I just need to confer with my client because we originally filed a jury demand, and what I want to ask him is whether he's willing to withdraw that so we could do a bench trial and get it done more efficiently that way.
Either way, a bench trial, jury trial, either way, but it's going to be on another date.
Okay.
All right. So I think we have your motion, your order, your proposed order. So,
can I ask how many days do I have before I can challenge the order that we're signing right now?
Once you get it, you have 30 days to challenge it. But Mr. Hudson, this is where it gets important. There are rules to this, and so just you saying I just want to challenge it, that's one thing, but challenging it properly so that you actually can have an effect that you're looking for, that's different.
I got you.
Okay.
Yes,
ma'am.
ma'am.
All right. You're excused at this time.
Judge, before we excuse these parties, is Mr. Samuels going to file a motion letting us know how we're going to move forward, and then we'll file an order about what happened here today, or do we go ahead?
No, we'll go ahead and file the order granting the default, and then Mr. Samuels just can send us an email or file something saying that he wants a bench trial versus a jury trial, or he wants to maintain his jury trial.
Okay, yes, ma'am. Thank you.
All right. And Mr. Hudson, please be mindful that whatever the next step is, you'll be getting notice from the court, okay?
Okay, thank you.
All right, thank you.
Thank you.
Your Honor, excuse me. Yes. May I speak? Jordan Mahoney, counsel for defendants on that Matthews versus Cerberus case
yes.
at all.
Yes.
So we spoke earlier when you called our case, and it appeared that plaintiff attempted to voluntarily dismiss the action, but that's not allowable anymore under OCGA section 91141. Voluntary dismissals now must be done with the consent of both parties, or they must be done within 60 days of the opposing party filing the answer.
Right.
So,
and how far outside the 60 days is it?
I can tell you when our answer was filed, Judge. 1 second. All right.
All right. While you do that,
let me. Now, sorry. Go ahead. Go ahead, Judge.
I was just gonna, because I'm in the middle of the 11 o'clock calendar. I have, I think, 2 more cases to do.
My apologies, Judge. Our answer was filed January 10th, 2023.
Mm-hmm.
And so what I was going to say,
so that would 531. That would make the dismissal outside the new rules.
Right. We answered on behalf of all defendants on that date in 2023. So
I'm sorry, 2023. Yeah.
That's right, Judge. All I was going to say is that
well, now for cases that were filed before the
pending cases, Judge.
I'm sorry.
Sorry, I didn't mean to cut you off, Judge. I apologize.
No,
I was going to say it's for pending cases.
For pending cases. Okay, so it doesn't matter when it was filed because we're all learning this. These are new rules for me too. So
yes, Judge. And I double checked. It says effective April 21st, 2025. I can actually screen share what I'm seeing right here from West Code of Georgia annotated. I'm
No,
using
I
Westlaw
got
to
you.
look at it. Okay, I'm using
I
Westlaw to
got
look
a
at it.
whole video that they sent us about it. This or I think it's a PowerPoint or something. So yeah, they just came. I think they're probably not even aware. Do this for me. Call them. Because sometimes they're not aware. And
Yes, I believe they're probably not.
yeah, I think they may have thought that because their case was pending before, because I think that's a misconception about the new rules, is that if your case was pending before the rule became effective, that it won't be affected. But that may be their issue. So just give them a call and let's see if we can do this old school lawyering style and figure it out. And if you all need to come before me for something, then I'm more than happy, even for a conference if you want.
Right. I was going to propose that I guess we could because we do want to the motion decided. So
Yeah,
I was going to
that's
propose that
fine.
we do like a proposed order.
Yeah, I'll
But
put you back on the calendar now that I'm clear. But yeah, I can put you back on the calendar, but call them and let them know that this is outside the limits of the new statute.
right. And
And
I was going
they
to send like an
may,
email copying him
yeah,
saying that we appeared for the hearing on this date and they apparently filed a involuntary dismissal that may not be authorized anymore under the new
yeah,
statute.
yeah.
And we would go from there.
Because I think them filing without prejudice means that they intend to awaken this case, and they may not be able to if they, under the new rules with the way they've done it. So, all right,
That is
just
well.
keep in touch with Ms. Powell if you all need to be put back on the calendar. Otherwise, we'll look at the case based on what's been filed.
Excellent, Judge.
All right.
Are we, and one more request, are we permitted to submit a proposed order?
Certainly. We love proposed orders.
Will do. Thanks, Judge.
We may
May
not
I
use
be
them, but
excused?
we like them.
May I be excused, Judge?
You may. Thank you.
Thank you so much.
All right. So, Mr. Austin, thank you for your patience. When I think an issue is going to be a little bit meaty, I'll hold it for a second so I can figure it out. All right. So this is Kamara and Jola. Is that correct? Versus Doe Turner and Atlanta Realtors LLC.
Yes.
So, okay, let's talk about this investment. Oh.
Yeah, and just for
Barry, I didn't forget you. I'm coming. All right, go ahead.
and just for context, Your Honor, I had this case on the exact same facts as this case and got a default judgment on that case too. But pretty much what happened is that my clients made a $200,000 investment to the defendants, and the contract states that the investment amount was supposed to be used to buy luxury vehicles and other goods. The defendants paid my clients the investment amount. They were supposed to get back $12,000 a month starting on December 1st, I believe, 2012. And they started paying. They paid December, January, and February, and then they just stopped paying. And
Okay.
so,
All right, let me ask you this.
sure.
What business generates $12,000 a month in return a month?
I do not know.
I mean, if it's not Bolivian marching powder, Mr. Austin, what business?
I did not get into the weeds of that. I didn't ask questions about what business. So I just, I was presented with a breach of contract claim. I determined that it was breach of contract, and
Okay, so they were supposed to get a return of $12,000 per month,
correct.
and they paid for how many months?
December, January, and February of 2013.
All right. And was there any reason given for the alleged breach?
Just that the investment opportunity that they had didn't make the money that they thought it would. And so that's why they stopped paying.
Okay, and when you say luxury vehicles and other goods, were the plaintiffs did they have any responsibility to I guess approve the other luxury goods, or was it contingent upon their action other than putting $200,000 into the hands of Atlanta Realty?
Sure. Just putting the $200,000 up as an investment. The contract is pretty plain. It simply just says $200,000 investment, return of 6% each month starting on December 1st, 2012. And the parties can terminate the agreement or ask for their money back anytime within 30 days. And that's basically all it says. Um, and it gives the reason for the investment to buy vehicles and other goods. And that's the extent of the contract, which tells me an attorney probably didn't draft this
Oh,
agreement.
I'm clear, Mr. Austin, that nobody who's got our training drafted that.
Right.
So in the four corners of the contract,
Yes, Your Honor.
the offer was, we're going to give you this amazing return in exchange for $200,000, the acceptance. The money was paid. The contract was breached because one version of the contract, the one provision of the contract is that the return is to be paid at the rate of $12,000 per month until when?
Until the parties terminate the agreement.
So this is an indefinite provision. Like the provision is, the contract is automatically renewable until death ad infinitum.
Correct. Yep, it's bare bones, just like that. If you see the document, the only termination provision is the parties can terminate within 30 days, and that's the only termination provision within.
Yeah, share screen for me. You got it?
Sure.
I just had a case recently where this gentleman allegedly contracted for repairs to his home, but the repairman didn't do what he asked and he kept paying. And so it was like a constant reformation, and there never was a meeting of the minds. And I was like, sir, you can't sue him for not meeting the terms of the contract because y'all never had a contract. Every time you said do this for this amount of money, he did something different and you gave him a different amount of money.
Yeah. Now I have a screenshot. I'll show it to you. Let me share my screen. Right.
Okay. Hold on. I thought my doctor was calling.
Oh,
no, it was a scam call.
Oh.
They're using Kaiser Permanente now to ask if you've been in a car accident in the last 2 years. It's just the amazing amount of scams out here. But anyway, okay, let's go. All right. Okay. Loan invested.
I'm sorry, Your Honor. So it looks like vehicle purchases, but I later found out it was luxury vehicles that were supposed to be being purchased.
So Sean Doe is not that's an actual person.
That's an actual person, correct.
Okay, because I thought it was like
the last case I had, the judge thought the same thing, but this is an actual person.
All right. Okay. And this is the total contract.
This is the total contract. Yes, Your Honor.
and it seems mutual in as much as either party can end the contract with with 30 days notice.
Correct. My prior judgment on the same facts, I'm still having trouble collecting that judgment, to be
Oh,
honest.
you're gonna have trouble collecting this one, Mr. Austin.
No, I'm pretty sure.
I mean, because this is as sketchy as the paper it's written on.
Yeah. Yep. I
Well,
understand.
what damages are owed to Mr. Kamara and Jola?
I calculated up until April of this year. It's a total of minus the amounts that they've given, the 36,000 that they've given, it's a total of $512,000. Now, to be honest, if they were never mind, I'm not going to speak to what they could have done to limit damages here. But to date, they haven't given back the investment amount or anything.
Okay, well, at the point that they breached, which I guess would have been March.
Correct.
So from March forward, this is the amount owed for the end of the contract, I guess.
Well, yes. Well, to the end of when I filed my motion for default judgment. That's to the point where I stopped calculating, which was April of this year. But it's June. Not sure if we can add that extra May and June.
Which would bring it up to
Another 24.
Yeah, 36, 536.
Yes, ma'am, 24, 34. Yep.
All right. Sometimes numbers are just numbers, Mr. Austin. So asking for on behalf of your clients, 536,000. Any other fees or associated costs?
No. I already know they don't have it. But
All right, so I'm going to go ahead and grant you, based on this contract, $536,000. All right. And you can go ahead, if you haven't sent over an order, send one. And how much are you charging for the business law class that you're giving to Mr. Kamara and Jala? You don't have. Is it included in the retainer? I'm just asking.
yeah. Yeah. I have talks with clients all the time about stuff like this.
Mr. Austin, I used to practice, I'm clear. I used to practice business law, and let me just tell you, everybody thinks they can do a contract. Everybody thinks they can do what we do. And I always tell people it is better to ask the questions, talk to an attorney, even if he's charging you a consulting fee, sit down and pay it. It is cheaper on the front end than to have us fix it on the back end. And they don't need us on the front end, but they sure will come running when it's back end.
Yes. You were speaking to the choir. I have a case where a young man signed an agreement and gave away 80% of his company.
Yeah. Because, let me just put it this way. I used to represent at one point professional athletes. So go ahead. Take it from there.
Yeah.
Yeah. So you understand.
I do.
All right. All right, sir. We'll go ahead and get that order out to you.
Okay. Thank you, Your Honor. May I be excused?
Yes, you may. Thank you.
you.
Pleasure meeting you, Mr. Austin.
You too. Have a good day.
Devontae June Taylor and Denise Eli Tuckenberry versus Michael Corday McKinney.
Yes.
All right, so Mr. McKinney is not present. I see a Miss Bagwell. Miss Bagwell, are you here for this hearing?
No, Your Honor, I'm not. I'm a summer associate. I was just observing for educational purposes.
I hope it's been educational.
It has, Your Honor. Thank you.
Welcome. All right.
Thank you.
So, Mr. and Mrs. Mr. I guess Taylor, Miss Tuckenberry, you are here for alleging that there was some sort of fraud.
Yes.
Okay, hold on. All right, here we go. All right, so you have filed an affidavit and a request for default judgment. Tell me what happened.
Okay. A loan was made to a friend of mine who I hadn't seen in years. We were going to go into some kind of business, into lawn care. Okay. He asked me to loan him my money so he could start the business.
Okay, so hold on. So this is Mr. McKinney.
Yes.
All right. So Mr. McKinney and you haven't talked in years, and then y'all start talking to each other about a business.
Yeah, he found me on Facebook, and we like knew each other from high school.
Okay.
Okay. So he was talking to me about the lawn care business, and it sounded good to me because I know you can make money off the lawn care business. But like I said, he asked me for the loan and I loaned him the money. And when I loaned him the money, we had a verbal agreement that he would pay me back my money.
Did you just listen to the last case, Ms. Tuckerman?
Yes.
All right. So you're starting a business with somebody who you haven't seen since high school.
Yeah, we weren't starting a business together. I was loaning him the money.
Okay, so why couldn't he go to a bank?
He has 3 jobs. He works like 7 days a week. He has money.
So then why did he need your money?
Oh, I had money. I had money saved up. So I was going to start a business. But when me and him started talking, it sounded good what he was talking about. He was going to start the lawn care business and then he was going to come and train me on the lawn care business. I was going to get my own set of lawn care equipment.
Okay, so what was the money how much did you loan him?
Okay, I loaned him $56,000, like from.
Wait, whoa. $56,000?
Yes.
Did you have anything in writing?
No, just a verbal agreement, and I have like my receipts from the bank and everything else. But 56,000 is not the total amount. The total. Go ahead.
Mr. Taylor, how are you involved in this?
He's severely autistic. It's
Okay.
just that some of that money was his money, our money saved.
Okay. All right. So, why would you give somebody that amount of money with no documentation or anything?
Because by him having all those jobs, he gets a good amount of income.
Which means he could have paid himself, but why would he need your $56,000 plus?
His money was already tied up in things. Like I was so anxious. I wanted to get this business started and it can make money. But the defendant.
Ms. Tuckenberry?
Yes.
You're one of those people where if you get an idea in your head, you're not going to be dissuaded. And unfortunately, you got an idea in your head that you were going to start a business and you took $56,000 plus and just handed it to somebody with no documentation.
Yeah, Your Honor, may sound strange, but I've never done anything like that before in my life. I know about scams. I know about romance scams. I know about all kinds of things that happen, but I think I'm under so much pressure taking care of my son. I take care of him totally. He has so many needs.
I have a son who's on the spectrum.
Okay. Yeah, it's a lot of stress. And I think that he got the loans because I was vulnerable and I was distracted because I've never done anything like that. And I needed something like I'll be 65 in September. I needed something like to make some money, to like, build for my future, like to have some kind of income. And I had a business plan in mind. It would work, but I just didn't think that he would steal my money. I really didn't think that he would do that.
Did you report it to the police? Did you report it to the police?
Did I just set up, this case?
Okay.
Yeah.
All right. So you said that he came to you and asked for a loan. What were the terms of the loan?
Okay. He got the loans and he was supposed to pay me back June the 10th, 2024. Everything, every penny.
And how much did he get from you?
Oh, totally, he got like $65,750. And this is why it jumped from the $56,000. I sent him a wire transfer of $9,000 from Wells Fargo Bank to Fifth Third Bank, his bank. Fifth Third stole the $9,000.
Ma'am, banks don't steal money.
Okay. Well, they held it. I'll say it like that.
Who told you that?
I have been in contact with Wells Fargo and Fifth Third for like 7 months trying to get my money back from them. Whatever they did with it, it was in their system.
You sent it to whom?
I sent it to the defendant.
And now Fifth Third and Wells Fargo are saying they don't have that money.
No. It took me 7 months, and I finally got in touch with the president's office of Fifth Third Bank, and they found the money. But the defendant set it up where it still went into his account. So that's why my $56,000 went to $65,750. Well, I mean, Fifth Third Bank had my $9,000 I was sending to him, and they kept it. And nobody would answer questions or anything. And then the Financial Bureau made Fifth Third Bank give me my money back. But when they were giving me my money back, the defendant had it transferred into his account because originally it was supposed to go to his account. After it was lost with Fifth Third Bank, I sent all kinds of letters and everything else, so they would return that $9,000 to me. Now this is another part to that. When Fifth Third Bank had my money and they didn't return it, the defendant was pressuring me because he needed the money to get more lawn care equipment. And so I gave him $9,000.
Did you ever see any lawn care equipment?
He showed me some pictures, but it didn't even occur to me that he may not be telling the truth about the lawn care stuff. I mean, I was so wrapped up in thinking, okay, I'm gonna get my business started. I'm taking care of my son, totally distracted because I have to think for me and for him. And I didn't think that the defendant would scam me. Yeah, he showed me some pictures. He showed me pictures of the trailer. He showed me pictures of the riding lawnmower, and then things need to
do. I can show you pictures of a rocket ship. It doesn't make
exactly. I swear, my mind frame, I don't know where it was because
I'm just my heart, Miss Tuckerberry. Miss Powell, was Mr. McKinney ever served in this case?
1 second, Your Honor. Let me check.
He was served by me like 3 times, and then
hold on, ma'am. Hold on.
Okay.
This is not legally.
Okay. Your Honor.
Yes, ma'am.
He was served, like I said, by me, and I turned those papers into you all, into the court, and they're filed. And then Miss Kiera sent them one last week.
So the affidavit of service the date for that is March 26th.
Okay, and who was he served by?
Certificate of service. I'm sorry, the certificate of service was March 26th. The affidavit of service was filed on April 14th. And then we did send service as well for the Road Side.
Okay, when I said who was he served by, so the original complaint was served by the sheriff's office?
Yes, ma'am. I'm looking into it to double check, but I believe so.
Yeah, did he file an answer of any kind?
He has not. He has not responded to the case at all.
Okay. All right. So the court is going to grant you the amount of $73,960. That's $65,700 in principal, $4,000 in attorney's fee. Well, no, you don't have an attorney, so I can't give you attorney's fees.
Yeah.
$537 in court costs, and you're asking for prejudgment interest. And I'll go ahead and grant you whatever prejudgment interest you're entitled to. Okay. All right. Now, Miss Tuckerberry, listen
Yes.
carefully. I don't understand why people don't understand this. But you don't ever give anybody money on just a say so.
Yeah.
You don't ever exchange money for anything that doesn't have paper backup with it. If somebody tells you, well, I'm going to start a business, and they have a business, well, you want to know, okay, well, who've you worked for before? Can I get, can I talk to your clients? Can I see your work? Can I see the actual, because you weren't even giving him money to start your own business. You were
Right.
giving him money to support. If somebody's telling you, I'm working 3 jobs and I have all this money, doesn't it, think about now what sense it makes to be working 3 jobs and you can't get a loan, and you don't have any money to do something else that you working 3 jobs and your money is tied up in other stuff, but you don't have any money, and you got to come to a vulnerable person who's taking care of another vulnerable person and take their money.
Yeah. All my life, I've seen all kinds of scams and everything else. I didn't think I was in one.
People get excited when folks start talking. I've seen it so many times. Well, we're going to start a business and we're going to do this. And they get that hype language.
Yeah.
But they never see profit and loss statements. They never see tax returns from his current business. They never see anything in writing that says, I have successfully started a business and I am going to use the money in the right way. Everything he showed you, he could have gotten off the internet.
Yep. Yeah. And I didn't think that all the way until the part where he told me, well, I think we should just like separate and all of this kind of stuff. And I'm like, what about the lawn care? It never entered my mind for this person that he would do this. It just never. And the pictures, you know what I'm saying? I saw the pictures. Okay.
So, ma'am, I'm going to give you the judgment. I don't know that you're going to be able to collect it, but if I were you, I would get an attorney to help you collect
Okay.
it. Because you're not going to be able to navigate what it takes by yourself.
Right. Your Honor.
But number 2.
Okay.
This sounds like a classic romance scam or fraud. So you may want to report it to the police. I know sometimes people get embarrassed, but he may be doing this to other people.
Okay.
If I were you, I'd file a police report. So just go down to the police station or call the non-emergency number. Because he not only defrauded you, he defrauded your son. Your son has a disability, so he's taking money from a vulnerable person.
Yes.
That's somebody we need to get off the street.
Okay. Those numbers that you quoted to me, can you quote them to me again?
It'll be in the order.
Okay, thank you.
A copy of the order, but yeah, you're not entitled to attorney's fees.
Okay.
But like I said, collecting money is hard. So you may wish to get you an attorney, because if he's doing things that are fraudulent, that money ain't going to be easy to find, and he's not going to willingly give it back.
Okay.
All right, but Ms. Tuckenberry, please. Like, think critically about stuff. You know, he may be talking sweet in your ear, but think about the fact that why would a man who is so successful need your money?
Right. Right. Absolutely. Absolutely.
All right, so we'll get the order out to you.
Okay. Thank you so much, Your Honor.
Welcome. All right. All right, Miss Powell, we're in recess until the 1 p.m.
Hey, Judge.
calendar. Yes, ma'am.
Okay, will you send me a picture of the notes that you took, of the numbers that you have?
I have the affidavit, so $65,700,
Wait, you're
$537.
pulling the numbers directly from the affidavit?
Yeah, she's not
Oh, I
entitled
can
to
do that.
attorney's fees, and she's asking for prejudgment interest. So if she pled for it, so she's entitled to it.
Okay.
All right.
Okay, see you soon.